But anyway, the PowerPoints also are available for local training, maybe just future reference for your own benefit. But you're more than welcome to avail yourself to those as well. So as I described, PowerPoint, me talking in the background, questions. If you have questions during the session, you can type them into the chat feature, and I will do my best to answer them live as we're going through. But I have two conditions. First is that, we're talking about laws that protect information. So let's stay on topic. The second, just as important, is try to keep your questions as brief and succinct as possible. I know that can be difficult sometimes, but it's awkward for me to sit here and read through a couple paragraphs while everyone else is waiting patiently. So if you do have something that is unique to your situation or unusually complex, we'll do one of two things. We'll either come back to it at the end of the presentation and we'll talk it out for the good of the order for everybody, or we'll take the conversation offline, and I'll encourage you to reach out to the office. The phone number's on the screen right now, as well as the URL for our website. On the website, you'll find email accounts for you to type in your questions. They come into the administrative staff at the first level. They're very good and very knowledgeable. They can usually get you steered in the right direction. But if they can't, then they'll escalate it up to one of our senior staff. We do our best to get back to you within 24 hours of sending us an email. Or, if you call and it needs to be escalated, again, we do our best to get back to you. And we try and get you headed in the right direction. Okay, so that takes care of all the preliminaries. Let's dive into this topic, laws that protect information. Interestingly, this is actually one of my favorite webinars. It's been quite a few years now, but this webinar actually was crowdsourced. Someone suggested to us, hey, why don't you guys do a webinar on these other laws that you're always talking about? So we did a number of things. We, sent out some surveys. We just asked for general input on social media. We went back and reviewed our case history and did some number crunching, looked at the metrics and picked out various laws where, we saw a lot of activity. And we picked, I think, 14 total originally. And I'd have to go through and see if we're still at 14 because we have made edits over the years. But that's the genesis of this webinar. And we've had some other suggestions for topics over the years. And some of those have worked out, some not so much. There's not a lot of material on some of these topics. But so I'll just put it out there. If after going through this session, if you think that there's some law out there that we should be covering, feel free to reach out to us and we'll take a look at it. And, there's nothing stopping us from amending these webinars to include new laws that you might be coming up against that, might be beneficial to everybody. Okay, so let's talk about, got to move over to the other screen here. Let's talk about why this topic is important. And there's two main reasons. First offhand, you need to know that there are other laws that can remove the discretion that exists in the right to know law. Okay, what does that mean? Well, some people mistakenly think that the right to know law is a confidentiality law, and it's not. Meaning that if you have a record that clearly falls within one of the 30 exemptions found in the right to know law, that it must be withheld from public disclosure, and that is not the case. Those exemptions are discretionary, meaning that you can have a record that falls within one of the exemptions, but you as an agency open records officer have a choice whether or not to release it. What the right to know law says is that you may withhold it. It doesn't say you must withhold it. Okay. But then we come to these other laws that we're going to be talking about here this morning. And usually, if there is another law that says a record is confidential, typically you must withhold it in order to satisfy that confidentiality. And if you go to Section 306 of the Right to Know law, there's language in there, to paraphrase here, nothing in this act shall supersede or modify the public or non-public nature of a record, et cetera, et cetera. Actually, that's not paraphrasing, that's an exact quote, but I digress. What that basically says is the right to know law defers to any other federal, state law, regulation, or judge's order that would otherwise make a record confidential. So, under the right to know law, you have a choice if the record falls within an exemption. That choice is whether or not you invoke the exemption in order to keep the record from public disclosure. However, if there is another law and that law says you must withhold this record, then the right to know law defers to that condition that you must withhold the record. Okay, and regardless of what the right to know law says, the other law and its confidentiality provisions trump the right to know law. Hopefully everyone understands that. Then the second major reason as to why this topic is important is the burden of proof. Now, under Section 708B, that's where we have all the exemptions. And typically, when an agency is withholding records from public disclosure, they will choose one of the 30 exemptions in Section 708B. However, you can also use the confidentiality provisions of those other laws, the ones we're going to be talking about here this morning, plus any others that you may be aware of that establish a legal basis for withholding records. And this is important because the agency is able to meet its burden of proof by citing the appropriate confidentiality provisions of these other laws, even if they never mention the right to know law per se. And there are confidentiality provisions in other laws that cover records that aren't specifically mentioned in the right to know law. So you could have no reference whatsoever in the right to know law in Section 708B regarding the confidentiality of a record, but there could be another law out there that says this particular record is confidential. That law, by you citing it in your denial letter and let's say subsequent appeal documentation, if it did proceed to appeal, would allow the agency to meet its burden of proof. Because if you're familiar with the right to know law, the burden falls on the agency to prove that the record is not public, rather than falling on the requester to prove that it is. Okay, so as you work your way through this process, by citing the other law, you have met your burden of proof, provided you're interpreting it correctly and so forth and so on. Okay, and the first law that we're going to cite is actually a good example, and that is CREA, the Criminal History Records Information Act of 1980. This applies to any person or agency that collects criminal history information, such as police departments, prisons, district attorneys, sheriff, courts, so forth and so on. Now, CREA itself protects criminal history, investigative, and intelligence information. Intelligence information is a good example of what I was just talking about. If you look at the right to know law, specifically, you would go to Section 708B 16, which covers criminal investigatory records. Okay, someone submits a right to know request and they're looking for information about a crime and the police investigation that took place. You would cite 708B16 as the basis for withholding that record. But let's change it up a little bit. Let's say that the police department, has a file on suspected gang activity within their jurisdiction. Okay, that's intelligence information. Now, under the right to know law, Section 708B16, or any of the other sections, there's no reference to intelligence information. Okay, as far as the right to know law is concerned, who knows? It may have been an oversight, or maybe they were aware of CREA at the time, but there's no, as far as intelligence information is concerned, there's no legal basis for withholding it by citing the right to know law. But if I go to CREA, intelligence information is specifically mentioned. Thus, I could use the confidentiality provisions in CREA to withhold the release of any police intelligence information from public disclosure. Under CREA, all of this information can only be shared with other applicable law enforcement agencies. This is also an interesting point because CREA specifically defines what a law enforcement agency is, as do other laws. For instance, let me think here for a second. There is another law that defines, it's Act 20. I'm sorry. And I think we're going to talk about that here. Maybe, maybe not. But anyway, video information. Okay. I believe it's Act 20. It's been a while here, and senior citizen itis is clicking in here. But under Act 20, video records, okay, can be withheld, or I'm sorry, let me get my act together here. There is a separate process for requesting video recordings taken or in the possession of law enforcement agencies. Okay, well, Act 22. Thank you, Kevin. Okay, saved me. Under Act 22, that also defines law enforcement agencies. Okay, but the definitions are different. For instance, under Act 22, believe it or not, a school district can be considered a law enforcement agency, which is important because under CREA, the definition of a law enforcement agency is much narrower. Okay, a school district would never qualify as a law enforcement agency under CREA, whereas it does under Act 22. There are some other interesting anomalies under Act 22, where it's basically any agency that employs a law enforcement officer. Okay, so you can see how that opens up a can of worms here. We've had private charter schools qualify as law enforcement agencies. It's kind of bizarre. But anyway, back to CREA. So any record that falls within the umbrella of confidentiality as determined by CREA, those records can only be shared with other law enforcement agencies as defined by CREA. And if they were to mistakenly or, intentionally share one of those records outside of that universe, they would actually be subject to sanctions, and some of those are criminal in nature. Now, if you need further information on CREA, there is an excellent handbook, and the link is on the screen right now, published by the Pennsylvania Attorney General's office. They are, more or less the owners of CREA, and they have several subject matter experts over there that, you can contact them for further clarification. But it's an excellent handbook. If you're here and you're from the law enforcement community, if you don't know about CREA, number one, you should. And in order to find out about it, check out this handbook and start up a conversation with the Attorney General's office. Okay, moving on. Act 30 of 2016 is kind of related to CREA a little bit, but it applies to emergency call centers, or what we call the 911 centers, or in certain circumstances, there are still some local call centers, that police departments run. This would apply to them as well, whether they be full-time or by shift. But they're labeled in the law as public safety answering points. But we're going to call them 911 centers, okay? And Act 30 protects individual identifying information, callers, witnesses, and victims. And when we talk about that individual identifying information, that would be the names of these people, their telephone numbers, where they responded from, and any home addresses. And now, the home address is protected, but not necessarily the location. So that's why you may see, for instance, there are online services that when a call is dispatched to a police department or a fire department, it will come up and show the location, but it doesn't give the exact address. Typically, like, right now I'm sitting in 333 Market Street, Harrisburg, Pennsylvania. So if there were a fire alarm, it would come out as at the intersection of 3rd and Market Streets in Pennsylvania or in Harrisburg. Okay, that's what the public would see, Cross Street, or the 300 block of Market Street. And if we were out on the interstate, it would show a mile marker, for an accident or whatever, rather than showing, an actual street address. And that is to protect the confidentiality of homeowners, and again, those callers, witnesses, and victims. Okay, so that's why when someone submits a right to know request to get specific information on a police incident, typically that request is going to be turned down because, number one, usually it would get referred to the dispatching agency, which would be the county 911, and they're limited by Act 30 in what they can legally give out. And I don't mean this to disparage 911 centers, but I am still surprised at the number of 911 workers who are not aware of this law, because we will get emails or telephone calls, or I've been at training sessions where I've mentioned this and suddenly they've perked up. And this is one of those laws that you should be on top of, especially if you work for the county or if you're a local dispatcher, because you're limited legally in what information you can give out. Okay, moving away from law enforcement, but still maybe related, is attorney-client privilege and work product. Okay, this applies to really any attorney and the conversations that they're having with their clients involving sensitive information. From a practical perspective, for local agencies and state agencies, we're talking about your solicitors or your chief counsels and their appropriate staff. The local municipality or the state agency would be their clients. So any of that communication, whether it be emails, reports, whatever, of a sensitive nature, and it involves, legal advice or strategy, that falls under the precepts of attorney-client privilege. In Pennsylvania, it's considered, part of the rules of evidence. Now, if, let's say, you have a borough council and there is a session or a conversation between council and their solicitor, and one of the council members goes off the reservation and repeats what was said. Okay, well, at that point, privilege is broken and it no longer exists because the conversation was repeated outside of that attorney-client relationship. So then people ask, well, what can be done about that rogue council person? there's nothing in attorney-client privilege or a legal remedy per se, but it falls within the purview of counsel and what the appropriate, maybe the borough code, first-class township code, or whatever would allow as far as sanctioning that individual. And, we've seen that happen. So then the question comes up, well, what about invoices? Because we see a lot of right to know requests where people want to see the legal invoices because, the question comes up, well, how much are we paying this attorney to act as our solicitor? What are we paying in legal fees? Because, it's too much or whatever. So I'm going to file this right to know request to see all the bills. The question comes down to how detailed are the bills? Okay, and if by looking at what the solicitor has put in the invoice, if you can discern legal strategy, then it is possible that attorney-client privilege may apply. For instance, if they submit a bill to the township that says, for the last month, I spent 4 hours researching this particular legal angle for the case that's coming up next month where so-and-so is suing the township, or I interviewed these witnesses to confirm our position on, if it's in that great detail, then yeah, attorney-client privilege may apply. But if they're just saying for the last month, I'm billing you 12 hours at this rate, then that would more than likely be considered a public record. When in doubt, I suggest talking to your solicitor directly and asking them, do you believe attorney-client privilege applies? If the requester disagrees based on a denial, they have the right to appeal and our office will work it out. Okay, we'll determine whether or not attorney-client privilege applies based on how we rule with the appeal. Okay. But this is also, if you need justification for applying attorney-client privilege in response to a right to know request, you can go to Section 305A2 and you'll find the specific reference in the right to know law that recognizes the strength of attorney-client privilege and how it can apply in the right to know universe. Okay, changing gears again, and admittedly, we jump all over the place with this webinar because of all the laws that are out there that protect information. Uniform Construction Code, more commonly known as UCC. This is Pennsylvania's statewide building code. It applies to any agency that possesses building permit applications, plans, and associated records. And what does it protect? Well, applications, building plans, specifications, inspection reports, and similar documents, that's taken right out of the law, for buildings constructed after 2004. Okay, that's important because prior to 2004, Pennsylvania's building codes and building permit application process was quite diversified all over the map. Depending on the municipality, you could have BOCA, the let's see, the life safety code, I think it was called. And there were, many municipalities had a localized, their own customized building code. After 2004, everybody had to use the UCC. Okay, so it's important because if you receive a right to know request for information pre-2004, you may have to go dig up files on which building code applied to determine what you can and cannot release. But under UCC, basically it's applications, building plans, related documents, okay? Now, the building permits themselves, these would be the permits that are issued in response to an application. Those are clearly public records. It's the supporting documentation that got us to this point that can be considered, or more than likely are considered confidential. Now, the question comes up, what about residential buildings? Because UCC typically covers commercial dwellings, or not dwellings, but commercial structures. Okay. we have a decision. It's called Ness versus York Township. It goes back to 2012, where our analysis extended the confidentiality provisions of UCC to residential structures in addition to commercial dwellings. Not so much on what the UCC says, rather what it doesn't say. I would recommend that you read the decision itself if this is pertinent to your situation. But essentially, what the appeals officer concluded was that all throughout the UCC, it specifically references commercial structures until you get to the privacy provisions where it no longer references specifically commercial structures, but rather structures in total. We use that as the basis for saying you cannot have plans for residential structures through the right to know process. And that decision has been upheld, and it's never successfully been challenged over the last 13 years. Or I'm sorry, over the last 11 years. So we've used that as a basis. It has been upheld. And if you should happen to get any right to know requests for permitting information regarding private residential structures, you can use the UCC and this court case or this decision as the basis for withholding those plans. And, looking at it from a common sense perspective, why would you give out someone's home plans? Okay, sewage permit applications covered under this as well, or are they covered under separate laws? Mary, I don't know. I don't think the UCC specifically gets into sewage permits. Okay, if we're talking about commercial structures or even residential dwellings. So whether or not there is another law that covers that, I don't know. I'd have to research that. I'm thinking UCC does not, but obviously, first place I'd start is the State Department of Environmental Resources or Environmental Protection now. That's where I would start with that and see what laws, if any, cover the sewage permitting process. Yeah, just thinking off the top of my head, that's where I would start. And that's a really good question. I'm just racking my brain here to think if we have any history on that. And the next thing I would check is our final determinations database and just type in sewage permits and see if we have any case law on that. I can't think of any off the top of my head, but that's a really good question. I'm going to have to look at that. Okay. All right. So now, if there is a zoning or a code violation, not a zoning violation, but a code violation that leads to a court action, okay, those records are court documents. And in Pennsylvania, most court records are considered public and would be accessible through the court's right to know system. So you want to take a look at that, the Rule 509 process, okay, but probably not through right to know. And the provisions of UCC do not apply to zoning, okay? That's covered by the municipality's planning code, which has its own set of confidentiality provisions, okay? So you'd want to refer to that. And again, because most zoning disputes are considered legal in nature, typically those would fall under the umbrella of them being court records. Okay, moving on. We're now going to change gears and get into the alphabet soup of health-related laws. And the first one we talk about is one that's familiar to a lot of people, the Health Insurance Portability and Accountability Act of 1996, more commonly known as HIPAA. Okay, now HIPAA applies to healthcare providers. It doesn't typically apply to employers although we are going to be talking about the employee-employer relationship with some other acts that we have coming up here shortly. It protects individually identifiable, or better known as personal health information. Now, why would this apply to local agencies if we're talking about health information that doesn't apply to employers? Well, you've got certain situations where municipalities, most commonly on the local level, may still be providing healthcare services. Certain senior centers, okay, are still operated by the county or through contractual relationships. They have a link to uh, these what I'll call senior center arrangements. Okay, excuse me. So you still have, under HIPAA though, you can still have employment considerations where an employee can approve the release of health information to an employer. Okay, but then the employer must keep that information secure. Okay, so there's kind of two angles that we're looking at HIPAA from for our purposes here. First, does the agency function as a healthcare provider, whether directly or through a de facto relationship with a contractor? You know, is there still like a county home of some sort that we need to be concerned about here? And then secondly, what if you have an employee of our local agency who voluntarily has given health information to the employer? Okay, HIPAA does cover that, although we're going to talk about some other laws that have a more stronger or have stronger confidentiality provisions when it comes to the employer-employer relationship. Okay, but based on, you could refer to HIPAA as the basis for not releasing employee health information, as well as the right to know law, as well as some of the other laws that we're going to talk about. One of which is the Family Medical Leave Act. Okay. Now here we are looking at this from the perspective of the government entity, the agency being an employer. So this would specifically be of concern for human resource leave administrators, as well as direct supervisors of employees, because it protects any leave or accommodation related information that could disclose the presence of a serious health condition. Ms. Waterhouse, no, not directly, but we are going to be talking about CDLs. Hang on, I promise you. Okay, so let me get into this. The key phrase here that we have in red is serious health condition. Okay. Under the Family Medical Leave Act, in addition to all of the other provisions, they take a look at medical conditions that can be defined as serious health conditions. Okay, and that information that leads to the conclusion that an employee may have a serious health condition is strongly protected under the Family Medical Leave Act. Now, number one, the information can be released to those who have a need to know. So an employee can voluntarily notify their supervisor, you know, I am prone to epileptic seizures. Okay. Now that supervisor is legally required to keep that information confidential unless they encounter a situation where there is a need to know. I'm not sure how to word that, but the people you're releasing it to have a need to know it. Practically medical personnel and first responders. So let's say that you're in the workplace, the employee has a seizure, okay? You call the ambulance, the first responders show up, the supervisor is present. So it is okay then for the supervisor to say, This employee has told me they suffer from epileptic seizures, just so that you are aware of that, to help the first responders in diagnosing and treating whatever situation they've encountered. Okay, that is legally acceptable under the Family Medical Leave Act. Otherwise, they must keep this medical information confidential. Now, here's one that you should also be aware of, and it has to do with an employee's leave usage. Someone submits a right to know request because let's say they're a nosy neighbor. Uh, my neighbor was at home all week. I know he works for the borough, and I just want to make sure that he put in a leave request. Okay, well, anytime you use, if you're a government employee, anytime you use more, or let me think here, 3 days or more of sick leave, you should be receiving, actually, it's not government employees, it's all employees. You should be receiving a survey from your human resources shop that asks you, was this absence due to a serious health condition? Because if it is, then your FMLA leave entitlement kicks in, and that leave is deducted from the balance that you're afforded under FMLA. So by releasing an employee's sick leave usage, you could be disclosing that they have a serious health condition, which obviously would be something you don't want to do. So as an agency, you want to be very careful about what, if any, leave information you release, because there is a very good chance it could be protected under the Family Medical Leave Act. Okay, it's somewhat situationally driven, but as probably you could get away as just a general rule of practice not to release employee leave information. Now, stuff like leave balances, where there's a monetary aspect to it, particularly if an employee is getting ready to retire and there's a leave payout, stuff like that, that may be acceptable because it represents a monetary value. But as far as specific leave usage, you want to be very careful about what, if anything, you release because of FMLA. All right, moving on. The next one, the Americans with Disabilities Act, or what's known as ADA. Okay, this also applies to most employers, and it protects all medical records, and it requires that medical records be kept separate from any other personnel-related documents. Back in a previous part of my career, I was the HR director for a large state agency, actually for a number of state agencies. And I remember when ADA came out, because at that point, as the director of the HR shop, I had access to benefit information and medical records. What happened, though, is that ADA said that we had to appoint only a limited number of employees, of staff, who would have access to the medical records. So we had to remove all those. Everything was paper back then, and create separate file folders for all of our employees. And all of the medical information was kept under lock and key, and only our benefits staff had access to it. I no longer had access to it. So, keep this in mind as well. And this is also covered under the right to know law, that, you don't release medical information, but under ADA, you absolutely cannot release it. And there are significant sanctions if you were to release it. Now, what if an employee voluntarily tells other staff that they have a health issue? Okay, then it's acceptable as long as it's not disclosed as the result of any sort of medical inquiry. And the example I like to use is the building evacuation plan. Okay, so you've got, a local agency, you're in a multi-story building downtown, and you've got an employee who works on the third floor, who has, maybe they have a back problem. All right. Well, then you've got another employee who functions as the fire marshal for the structure. Okay. And we all know what that means. All right. So in order to have an effective evacuation plan, they send out a survey to all the staff. Is there any needs that you have for assistance with evacuating the building in the event of an emergency? So this first employee writes down, I had back surgery and I have trouble walking down steps. So I'm going to need help getting out of the building. Okay, well then the fire marshal in turn amends the evacuation plan to ensure that this person, is maybe evacuated to the third floor stairwell and staged there in place for the fire department to come and assist them in the event of an evacuation. Okay, so the employee, through a non-medical inquiry, has let the employer know that they have a health issue, their prior back surgery, and they're going to need help getting out of the building. So now it is legally acceptable for the fire marshal, in the event of an emergency, to notify the fire department. We have an employee on the third floor who can't walk down steps. They're staged on the third floor stairwell of the fire tower, and you have to go there to evacuate them. Okay, all legally acceptable circumstances for the release of employee health information. Okay, so you see how that works. Otherwise, health information cannot be released under the Americans with Disability Act, which you can refer to, because it still amazes me that people file right to know requests for health-related information for public employees for, whatever reasons, usually being nosy. Sometimes it is justified, but they're just not using the right mechanism to get it. It's not public information, but maybe they, as an insurance worker or whatever, have a right to it. They're just not going about it the right way. But the information is denied under right to know, ADA, FMLA, whatever. Okay. Changing gears again. Let's talk about schools and the Family Educational Rights and Privacy Act, or more commonly referred to as FERPA. Okay, FERPA applies to public and private schools, and they can be primary, secondary, post-secondary, meaning colleges. Okay, FERPA specifically protects individual educational records, such as report cards, transcripts, any records of discipline that would be considered part of the educational record for a child under the age of 18, as well as an individual who's not under guardianship. Okay, now, so you're thinking, well, wait a minute, what about like a listing by the school district of all those who made honor roll? Or, wouldn't someone's sporting accomplishments be considered part of an individual educational record as well? Well, they are, except that the FERPA allows for the extension of directory information, and that's what this would fall under, where you're not giving out like a specific transcript, but you're saying, this employee got a 4.0 GPA this last quarter, so we're, recognizing their accomplishments. That's acceptable, as well as, maybe the kid who, got a scholarship to a D1 school for their, sports accomplishments. Okay, that's, the signing ceremony that you'll see. That is considered directory information, and it is acceptable to release that. Then aggregated data, okay? You can't give out like specific test scores for each student, but if you want to give out the average for like our whole 9th grade, and there are all kinds of reports required by the Federal Department of Education, as well as the Pennsylvania Department of Education. And if the school district wants to tout like a rise in test scores, by saying that all of our ninth graders increase the aggregate score for this specific test protocol and release that to the media, that's acceptable, as well as releasing aggregated data to as response to right to know requests. Now, I've had this conversation with superintendents. What if the population of who took this test is so small and so detailed that someone who knows what they're doing could come in and slice and dice the data and actually identify specific students? In that case, if you believe you can support the denial based on the logic that you're using, then I would say go ahead and do it. I mean, at worst, you'll be told you were wrong through the right to know appeal process. But if you were to release information and a specific student could be identified based on test scores and being able to slice and dice it, then the potential exists that it would be considered a FERPA violation. And FERPA does have sanctions built into it. I think it's the withholding of federal monies to the school district, which could be significant. I'm not aware of any FERPA sanctions actually taking place. I am aware of many districts who have withheld records based on a fear that FERPA would come into play, and they've been overruled. But that's worst case scenario. It's usually just a minor slap on the wrist saying, hey, you were wrong. Okay, does this extend to transcripts requested during the hiring process that may be on file for public employees? Yes, it does, Mr. Bria. If you look at, I think it's 708B9 that covers employees, public employees, and transcripts are specifically mentioned in there that that you can withhold them if you want to. Okay, and again, because it's the right to know law, okay, just to clarify, the hiring process, FERPA would not apply if the person is not a student, okay? But the right to know law would apply for anyone hiring, whether they're a student or not, okay? Just to clarify where we're at there. Okay, another good question, but 708B9, I think, is transcripts are specifically mentioned. If not, it's real close to B9. Okay, all right, now, if you receive a right to know request from a parent saying, I would like information on my child, okay, under FERPA, because it's an individual educational record, it could be denied. However, FERPA does have a specific mechanism for a parent or guardian to get the records of their child, okay? And this is somewhat frustrating because we will see right to know responses where the district is denying it, saying, no, under FERPA, this is an individual educational record. But then they don't clarify that you can use this mechanism under FERPA to get the records that you seek. Basically, if they file a right to know request, you're saying, I believe these records are public. Well, under FERPA, they're not public. But yet, if you're the parent, you do have a right to see these records. So you would think it would be incumbent under the right to know process for the agency, for the school district to say, you can get these records, you're just going about it the wrong way, here's the right way. Unfortunately, they don't always do that. So, shame on you. But eventually, after much frustration, the parent usually gets what they're looking for. Okay. Now, what about law enforcement, campus police departments? Okay. FERPA does cover colleges, but if a student gets themselves in trouble with the law, with campus police, those records are not protected under FERPA, and it defers back to CREA as to whether or not those records should be released or not, okay? So you've got the right to know law, which defers to CREA, then you have FERPA, which also defers to CREA in the event of any sort of criminal charges being filed, okay? And then we get into the whole video thing, going back to Act 22, law enforcement, so forth and so on. And I just want to say that from a right to know perspective, where FERPA has been invoked to withhold video records, and school districts have claimed these are not public because of FERPA, we're still hashing this out in developing the court records and the way that the courts are headed with the release. There have been some court decisions where they've said, yes, the district is correct. This is an individual educational record and should be withheld. There are others where the courts have said, no, these are public records. And then the most recent ones have said, these are public records, but you need to cloud out students' faces, or use that software that makes it all pixelated, so you can't tell who's who. Okay. And we're still moving forward on that. The courts, this is a developing area of the right to know law, as well as FERPA. And, I'm just going to say, you just need to pay attention to the decisions as they come out. Okay. And then student health records, they are considered part of an individual educational record, and they would be withheld. Okay, then you have the Pennsylvania Public School Code. This is just more or less an extension of FERPA, the federal law, down to the state level. And again, it would apply to all public school employees and officials that they fall under the umbrella of not being able to release school records. But it does also include health-related records, and this is important in Pennsylvania because we have school nurses, nurses' aides, and the like. Any records that they generate as a result of serving the student population are considered confidential under the Pennsylvania Public School Code. So, for instance, if you have a student who every day they have to take medication at lunchtime, so they go to the school nurse's office where they're given their medication, any notes that are kept on that, okay, are considered confidential under the public school code. And you can use that as your legal basis for withholding that information. Okay, the Pennsylvania Motor Vehicle Code. Earlier we had a question about CDL. This would be where we're going to talk about this. Okay, the Motor Vehicle Code applies to the Department of Transportation in any agency, meaning, like a local government or any other state agency that's in possession of driver records. And it so happens that a license, whether it be your regular Class 3 license or a CDL license, and all of the associated records, okay, are considered part of the driver record. So, basically my license is part of my driving record that indicates I have approval to operate this specific vehicle. So we extend that to vehicles of a certain gross vehicle weight or of a certain configuration that requires a CDL to operate. So the fact that I have that CDL is part of my driver's record and is thus considered confidential under the Pennsylvania Motor Vehicle Code. Okay, and a drug test is part of my driving record, because if I were to fail the drug test, then I would no longer be qualified under the provisions of CDL to operate that specific vehicle. Okay, so going back to the question, are the results of a drug test considered a public record? They would not be under Section 6114 of the Pennsylvania Motor Vehicle Code because it protects my driver's record. Okay. Now, what if, as a result of failing my drug test, I would be charged criminally? Okay, well, then that becomes a court record. And like I said earlier, in Pennsylvania, the majority of court records are considered public and are accessible through the court system, even though they may not be accessible through the right to know law. Okay, so that's how all that works out. It just depends how far the situation escalates as to whether or not it would be ultimately considered a public record or not. Okay, interesting one. I realize we're gonna run past the hour, but I never promised you that these were only an hour long. Federal Copyright Law of 1976. Okay, this is an interesting one. Let me go into it a little bit. Okay, now it applies to anyone claiming or using intellectual property in the form of authorship. Okay, that's what copyright is. If you want to get into defining copyright, you're claiming that the records have some sort of intellectual property in them that you have authored. You're claiming copyright protection on that original thought. So specifically, the copyright law, the federal copyright law, protects records where the author is claiming original thought. For our purposes, it's usually an engineer or architect's plans or drawings. Okay. Now, this is where it kind of gets interesting because there's some misunderstanding on just what copyright is. And we'll see, we'll be working in a township somewhere and we've got these blueprints, okay, and they've put a stamp on them. Okay, well, that must be the copyright. No, it's not. Typically, the first stamp you'll see is from an engineer or an architect. It's their licensure stamp. Where they're affixing the stamp to the drawing they prepared to indicate that I am a legally certified architect or engineer, okay? Yeah, we'll just leave it at that, okay? It's not necessarily claiming copyright. However, if they believe that their drawing in some way represents original thought, they may affix a copyright stamp to it. They don't have to in order to invoke copyright, but usually that's what they do. So they'll affix a second stamp that says this material is copyrighted. Now, honestly, that can be a little difficult to uphold when you've got what I'll call uniform standards for construction practices. That, if they don't follow the uniform standards, then they're outside of code. Okay, so it baffles me sometimes when we see an engineer claim copyright when all they're really doing is applying uniform commercial standards for, I don't know, maybe stormwater drainage construction or laying out a subdivision and the utilities that go into that subdivision. All right, so yeah, it's just based on experience that I'm saying that. I don't want to get off track here. Now, under the right to know law, requesters can inspect a copyrighted document. They just can't have a copy of the copyrighted document. And the case law there is Ali versus the Philadelphia Housing Finance Authority, okay? They can, if you're familiar at all with the right to know law, you have two options. One is I want a copy. The other is I want to inspect the originals, okay? So if they come in and say they want to inspect, then they can see the copyrighted record. It's just that they can't take a picture of it or have a copy. Now, what if you should turn your back and they pull out a cell phone camera and take a picture? The dispute is not with the agency, but rather the dispute is between the person claiming copyright and the individual who would allegedly misuse the copyright. And taking a picture in and of itself is not misuse, okay? But it becomes a legal issue between the other parties, and the agency does not, in most cases, assume any liability. And That's how that would play out. Okay, just so you're aware of it. We get this question, I'm going to say 2 or 3 times a year, with copyrighted information. It's kind of an interesting area of the law. Okay, changing gears once again. Child Protective Services law. Okay, well, why would this apply to government? Well, what if you're a township and you have a summer parks program and you have volunteers or employees, interns, whatever, who have regular contact where they're supervising children. Okay, they have to go through the child line process of a background check, et cetera, and making sure that there's nothing preventing them legally from having contact with children. Okay, and let me go back to the previous slide. We've got a question that's come up. Would the person or agency that created the plans need to be notified of an unauthorized picture of their documents? Legally, no. There's no requirement that requires the agency to make the person claiming copyright aware that someone has taken a picture. It's not until actual misuse of the copyright that any legal issue actually rises to a level of notification. And even then, I'll go back to the statement, the dispute is between the parties creating and the parties misusing, not the party that's necessarily holding the record. Okay, good question, Erica. Okay, but back to Child Protective Services law. So we're talking about, just our example, the Summer Parks program. Now, if there is any sort of documentation related to a person successfully getting their child line, or for that matter, unsuccessfully getting their child line clearances, all of those records, the applications, the reports, etc., are confidential. The fact that someone has successfully received their clearances can be released because, you may have parents who are concerned. Is everyone here approved for, their child line clearances? The agency can say, yes, they are. Here are the clearances themselves. But any records related to obtaining those clearances would be considered confidential. Then what about an investigation? Okay, so you've got a kid that shows up for a summer program. One of the volunteers gets suspicious about, bruises or maybe something that child says. So they are then legally required, okay, they don't have discretion. Under the Child Protective Services law, they must notify the appropriate authorities to initiate an investigation as to whether that child has been the subject of abuse or not. Well, everything related to that investigation is also kept confidential, okay? And this can be tough because what if, and this is history here, but you've got a divorce taking place and it's contentious, okay? It's getting ugly. So you've got one parent claiming that another parent is abusing a child, okay? And sometimes it's just by inference. Well, legally an investigation needs to take place. And maybe it's not even the parent. Maybe it's suspected abuse that's been reported by a volunteer. And it may be valid. It may simply be, an unusual circumstance where the injuries were not suffered as a result of abuse. But still, you've got parents, throwing hand grenades back and forth. So one parent files a right to know request for summaries of an abuse investigation because it's come up in the divorce proceedings. Yeah. And suddenly the agency is in the middle of all this ugliness. Well, you've got to stay the course. And with the right to know law and the Child Protective Services law, you can't release any of this information. Now, hopefully the parent has a good attorney where they're filing subpoenas to get this information to clear the air, okay? A subpoena is something entirely different than a right to know request, okay? And you're talking about 2 different levels of investigation. Right to know law, it's not a public record. Child Protective Services law, clearly not a public record, okay? If you've got a subpoena, that's something different. Immediately run to your solicitor and let them deal with it, okay? But otherwise, that's how you would approach this whole issue when it comes to suspected abuse and the records associated with that. Because it can get tough because a lot of times under the Child Protective Services law, you have no choice. You have to initiate an investigation. Okay, and then there's a related law. And this is interesting because just last week, I was meeting with the new agency open records officer for the Department of Aging, and we were talking about this. And it's the Older Adults Protective Services Act. Now, it only applies to employees and administrators of elder care facilities like senior centers. Okay, so now we're not talking about something like a summer program, but specific facilities. And what this law does, again, it protects all reports of abuse in the associated records, the investigatory material, and so forth. And I was thinking for a year or so that maybe we should take this out because we haven't seen a lot of activity, at least from my perspective. But after meeting with the Arrow last week, I think in recent history, there were 27 cases where the department raised this act as the basis for not releasing investigatory records. So there's still a lot of activity on the local level with both the state and the counties where people are filing right to know requests to see investigation materials related to elder abuse. So we're going to keep it in. Okay, but any adult over the age of 60 who cannot more or less take care of themselves, they're impaired in some way, that their thought processes, and I shouldn't be talking about this because I fall within this category and I was having trouble with Act 22 earlier. But anyway, just a little levity there. It applies to anyone over the age of 60 who, for obvious reasons, can't really take care of themselves. Okay. And then we have just some that are kind of random here. But back during the midst of COVID, there were a lot of right to know requests for medical records and amalgamated or aggregated data. Okay, and the Department of Health was invoking this law, the Disease Prevention and Control Act of 1955. I think the legal mechanisms have pretty much run their course, but I know that the legislature is still taking a look at this in redefining this act and clarifying their intent with this. But basically what the Department of Health was saying, or county health departments, was that any COVID-related information that they had collected was considered confidentiality or was considered confidential under the confidentiality provisions of this act. Okay, our office disagreed with that. We said, look, if it's individual, it's confidential, but if it's aggregated, it's public. This went up through the courts. The courts pretty much supported our decision, and I think that's where we're at today. Now, the legislature is kind of revisiting this, and you see it coming up in committee periodically. Whether or not it will rise to a floor vote, I can't say. Usually, we just don't know about those things until like 3 days before it happens that, this issue is on the calendar and it's coming up for a vote. But we're going to keep it here just because I think it's kind of interesting in what we're seeing. Okay, final slide, just some miscellaneous things. W-2s of public employees are confidential. Anyone's W-2s are considered confidential under the Internal Revenue Code. You do not, people will submit right to know requests. I'd like to see the W-2s for these employees because they want to know, their salary information. You're not going to get it through the W-2s. Payroll records, maybe. W-2s, no. Okay, and then an extension of that, the Taxpayer Bill of Rights, it makes it a misdemeanor to release any confidential tax information, whether it be for public employees or, private individuals. You don't give out tax information. Same way with the Local Tax Enabling Act, or what's known as LT. Okay, that also protects tax information and tax returns that may come into the possession of an agency through some sort of investigation. Okay, whether it be, police criminal investigation or civil litigation or whatever, any tax information is considered confidential. And then home addresses and dates of birth. This kind of comes out through case law related to the right to know law, where originally in the right to know law, you don't see references to home addresses or dates of birth. But through case law that specifically cited, the decisions specifically cite the Pennsylvania state constitution and the
legal right to privacy, okay, constitutional right to privacy, the courts have said that home addresses and dates of birth, insofar as the month and the year, I'm sorry, the date of birth, except the month and the year, without the actual day, are considered confidential. Okay, I didn't say that clearly. Home addresses are clearly confidential, and we've extended that. You know, originally it was public school employees. Now we're saying wherever possible, any home address should be confidential. Let me hopefully speak clearly about dates of birth. If requested, you can release the month and the year, but not the specific day. That's where we're at now. If that expands based on issues related to identity theft, we'll let you know. But if someone wants specific dates of birth, month, year, but not the day, okay, that's where case law is right now. Okay, all right, that brings us to the end of the presentation. If there are any other questions, now's a good time to get them in. But I want to direct you to our website. Okay, copyrighted. Mr. Teplitz, good afternoon, or good morning. Okay, are you saying that just because a document has a symbol on it, it can be withheld? At this point, yes, but I would go back and read the decision on Ali. I think the courts have pretty much said that if it's covered by the copyright and you can claim copyright either with your copyright stamp or there is inferred copyright, then it should be withheld under the right to know law. Okay, even if it doesn't have a symbol, if copyright is somehow implied, you can claim copyright there as well. And if the requester is disputing whether or not copyright is appropriate, they can appeal that to our office, and our office will take a look as to whether it believes copyright is appropriate or not. Or they may defer it to, you know, the appropriate legal jurisdiction when it comes to actual copyright. But I think that's where we stand right now. But Ali is the, you know, the seminal case that I would look to for clarification on that. Okay, hopefully that at least steers you in the right direction. Okay, and where I would get further information on that is our website, because we have a case law index where we mention Ali, and you can pull up the link to read the court's decision, as well as our final determinations database, which has like 30,000 plus decisions in there that our office has issued, many of them involving copyright, as well as, you know, all the other legal issues surrounding the right to know law. So you want to take a look at that as a good resource. Any training information, you know, earlier I was talking about the videos that are kept on our website as well as the PowerPoints. Take a look there. If you have further questions after we finish our presentation here this morning, you want to email our office or call with your questions. And like I was saying earlier, we'll be happy to help you out. Okay, we can't answer requests for you. We can't provide legal advice, but we can point you towards decisions that we've made in the past where maybe the legal arguments and the factual basis were very similar to what you're talking about. If you're a real geek on government transparency, maybe you want to subscribe to our Twitter feed, where every morning at 8 a.m. we will wake you up and give you all the news that's fit to print on government transparency, decisions we've released, training opportunities, and the like. Okay. So I think we're at the end of the presentation. I'd like to thank you for your participation this morning, and great questions, keeping me on my toes. I'm going to go back because I know that there were a couple questions that kind of piqued my interest, and I'm going to have to go back and look at things. Taxpayer Bill of Rights, does this count for personal tax returns, real estate taxes paid per capita, etc.? Yes, in most cases, Bev, it does. But again, you want to go back, and I'm going to recommend read the Bill of Rights to make sure that it applies to the particular facts that you're concerned with. Okay, I don't want to make generalized statements that then you take and run with, because there's always exceptions and exceptions to the exceptions. I'm just putting that out there to make you aware that there is another law that makes records confidential. It's up to you then to go in there and take my generalizations and apply them specifically. And if you still have questions, go talk to your solicitor, go talk to your chief counsel to make sure that you're comfortable with whatever provisions you're applying, because they're the boots on the ground. I'm just talking in generalities. They will take a look at the specifics and make sure that you're applying the provisions correctly. That's probably your best resource. Okay, I'm going to go ahead and sign off. Again, thank you for your participation today, and we look forward to seeing you at future webinars. Bye-bye.